So what happens in the sale of real estate when a seller is not competent to sign a deed? Well, folks, in this instance, the first question we always ask is whether the seller has an estate plan in place. And part of that estate plan, we presume, would be a durable power of attorney. So we'd ask for a durable power of attorney. Now, what's a durable power of attorney? Well, to put it simply, a durable power of attorney is an agency. And it's basically an agency that anyone can form where they designate another to act on their behalf with respect to their assets for the most part. Now, this agent that is designated is called an attorney-in-fact. And the attorney-in-fact basically has the ability to step into the shoes of the maker of the document in order to handle the affairs, the financial affairs in general of the maker of the document. Now, there are some additional powers that we do give to this agent inside a durable power of attorney to represent in front of Mass Health, Medicaid is one of them, and then another would be to represent the individual in front of a court, in a court of law, along with having some general powers like the power to make gifts. So the question here would be, is there a durable power of attorney? Now, for previous videos that I've shot in the past concerning these matters, these issues, make sure you check out the links in the description, because I do have some other videos that I did shoot in the past that were shorter, meant to be definitions. But back to the situation that we have. So our individual is not competent to sign a deed. And the first question is whether they have a power of attorney. Now, if they don't have a power of attorney, what next? Well, in this instance, the family, the loved ones, would then need to approach the probate court in order to get the power to sign on behalf of the individual. And that process, that legal process, is called a conservatorship. Now, Massachusetts has the conservatorship process, but some other states may not and still recognize it as going for a guardianship. So what's the difference? Well, with a conservatorship, this is a legal process that is usually handled by the probate court, where friends and loved ones can approach the court in order to request or petition the court for the authority to act on behalf of the loved one that may not be competent to sign. Now, with the conservatorship, this would be for the handling of someone's assets while they're still alive. Now, when filing for a conservatorship of a friend or a loved one, typically what happens is when we have real estate involved, there is another step that has to be taken in the process. It's called, in general, a license to sell real estate. And this is the authority to actually sell real estate, to sign on behalf of the individual that cannot sign their name. Now, how does this compare to a guardianship? Well, in Massachusetts anyway, a guardianship is a petition. Once again, it's a legal process by which friends and loved ones can petition the court in order to take care of the person of the individual. So things like medical treatments and handling the everyday affairs of the person other than the assets. That is something that can be requested through the court in the form of a guardianship. And with both processes, medical information does have to be presented to the court. It's called a medical certificate. It has to be completed by medical professionals in order for the judge to see what the mental state or the physical state of the individual is at the time of the filing. And it is a whole process, and it does extend on for as long as the person is alive. So now, if the person does have an estate plan in place and they have a durable power of attorney in place, then the agent, the person that's designated through that document, will then have the ability to step into the shoes of the maker and sign that individual's name, sign that person's name in order to complete the transfer of the real estate. Now, if that document's not in existence, then once again, the family and friends, loved ones would have to approach the probate court, petition the court for a conservatorship over this person in order to have the ability to step into the shoes of the person with the court's authority, with the court's permission, to sign the individual's name and sell the real estate. So that information would need to be presented to the court as well in order for them to receive that authority. Now, if you're watching me on Facebook, make sure that you like the video. If you're watching me on YouTube, make sure that you subscribe to the lower right-hand corner. I once again have included some of my prior videos in the description. Links to those videos in the description, which are meant to be shortened definitions and to help bring forth some of the issues that we discussed here today. If you're watching me on Facebook, they may be included above in the description, but there are links there, so check those out. Now, if you're watching me on YouTube, some of my other videos will be appearing here. There'll be a list and some other related videos to this one. So make sure you check those out as well. Dave Ceruolo, CeruoloLaw.com.